Law College. I welcome all of you to this tape. It is believed and emphasized often that justice should be the end towards which law is used as a means. In furtherance of such justice to be done, at times it is important for all of us to prevent courts of subordinate nature from acting arbitrarily or irregularly in the exercise of their jurisdiction. To keep in check, such measures have been coded under the CPC, vesting powers with higher courts, which is popularly referred to as revision and review. That's our topic for discussion today. To throw light on this significant aspect of civil litigation, we have an esteemed guest joining us today as our resource person, Mr. Yeshu Mishra. To welcome our guest speaker, I request our IQAC coordinator, Mr. Manoj Kumar Hirimat, to take the stage.
Thank you, Shreyaja. Yeshu Mishra sir, I extend you warm welcome once again. And in our endeavor to train our students with the practical aspects which are required in the civil litigation, we have started this lecture series, and Vivek is successful in getting senior lawyers and judges in delivering lectures which are required for students to start their career with a practical knowledge. So in that direction, today's lecture is also going to be very useful one, sir, because once the litigation is over, a decree is passed, what is the next stage? The students will be having so many questions about that. So in that direction, your lecture on review and revision in under CPC is going to be of immense help. So with this, I again extend a warm welcome to you, sir. I guess floor is open to sir now.
Good morning, everyone.
Just a minute, sir. We would like you to be introduced to all of our participants today. Thank you, Manoj, sir. I now request my friend, the wonderful Snehalata Chaturvedi, to introduce our guest speaker for today.
Thank you, Shreyaja. Welcome, sir. We all have been attending many sessions since past few weeks. This particular session on review and revision under CPC would be conducted by Mr. Yeshu Mishra. We have here Mr. Yeshu Mishra. He graduated from Vidyavartha Law College, University of Mysore in July 1999. After that, he joined the chambers of senior advocate late Shri S.N. Krishnan from April 1999 to December 2001. And then he practiced in the chambers of Justice Shri S.N. Satyanarayana from January 2002 to August 2003. He was also one of the founding partners at Indo Legal Incorporation, Bangalore. Presently, he is a senior partner in the firm Haranhalli Law Partners. Now, with respect to his profile, he has an extensive experience in the matters of writ petitions, appeals, civil revision petitions, company petitions, arbitration matters, and public interest litigation. In fact, he has engaged with over 2,000 clients, including both individuals and corporates. Thank you for joining us today, sir.
What you, sir?
Good morning, everyone. Thank you for the introduction. I am grateful for this opportunity to be addressing students from such a prestigious college. One correction. I mean, again, we are going to be talking about corrections only today with review and revision. But my correction is, by mistake, during the introduction, my senior's name was mentioned as M.S. Krishnan. It is N.S. Krishnan. And I have a bit of an objection for that. Because my senior, I hold him with high regard. Anyhow, it's just, in a lighter vein. My senior was N.S. Krishnan. And he taught me basically the basics of civil law. And he was a very great man. He had very good knowledge of the civil procedure. And what little bit I have learned from him, I will try and share it with you today. Now, like Sri Raja said, that for us to question orders of courts, there must be provisions provided under the code itself. And there are various provisions under which orders of various courts can be questioned before various appellate courts or revisional courts, or like in a review, the court which passed the original order itself. So today the topic for discussion, as you all know, is section 114 and 115 of the Code of Civil Procedure, review and revision under the Code of Civil Procedure only. Because review and revision otherwise would be a very huge topic, because review and revisions are provided under various enactments, and it would be difficult to discuss about them in a limited time of 1.5 hours. Now, review and revision, if they are provided by a code alone, these are general principles. If they are provided by the code alone, can be remedies available to an aggrieved party. If review or revision is not provided under the statute, then there is no recourse, there is no inherent power for a court to review or revise an order. Now, basically, these are two very different remedies. Review and revision are remedies which are totally different from each other. The revision jurisdiction is more of a part of an appellate jurisdiction. It is a part of an appellate jurisdiction, but it should not be confused that appellate jurisdiction is akin to revision jurisdiction. Appellate jurisdiction is much bigger jurisdiction, a wider scope for dealing with orders sought to be corrected. But a review jurisdiction is much narrower, and it lies to the authority or court which passes an order, and it gives an opportunity to the same authority or court to correct itself. Now, the scope given for correction, either under revision or review, it will be prescribed by the statute itself. If it is prescribed by the statute, then the scope for review or revision are limited. They are not wide open. An appeal, generally, especially under the Civil Procedure Code, is a remedy which is wide open, which is literally rehearing of the case, reappreciation of the facts, reappreciation of the law involved. But review and revision are narrower remedies, smaller remedies, which are limited by the statute itself. Now, when we go to the question of review and revision separately, we will see what are the limitations, what are the prerequisites for a party to seek a review or revision. Now, I would like to start with the section 114, read with order 47, which provides for a review of an order. Now, review is provided for under the Code of Civil Procedure under section 114 and order 47. And a review is essentially an order. An aggrieved person can question an order before the same court and seek a review of the order on certain grounds, not on all grounds. Like I said, it is not, the scope of a review is not reappreciation of facts or reappreciation of law. So there are limitations to the review. Now, what are the limitations? What are the prerequisites? We will go through them a little later. Now, a review, like I said, lies to the same court against an order passed by it. An application can be made by an aggrieved person to seek a review of the order on certain grounds, which we'll come to. And a review can be sought within 30 days from the date of passing of the order. Article 127 of the Limitation Act prescribes 30 days as limitation to seek a review. Now, once we are in limitation, or if we are out of limitation, then again Section 5 of Limitation Act will apply, and we need not go into that. It is only if sufficient cause is shown, then the court has powers to condone the delay also. But basically, Article 127 provides for 30 days. Within 30 days, an order of review can be sought against an order passed by the court. before the same court. Now, a review is in common language is a relook, another look at the order passed by the court, by the same court, but restricted by certain statutory restrictions, limitations. Now, the essentials of a review will lie against an order of the court to the same court. Basically, three conditions have to be fulfilled. I'll screen share the slide. Kindly see. If an appeal is allowed, from such an order and an appeal has not been preferred, that is the first condition. A review can be sought of an order against which an appeal is allowed but not preferred by the party. Instead, the party prefers a review petition. Then, if an appeal is not allowed, then a review petition can be preferred. Thirdly, from a decision on reference from a court of small causes to court which passed a decree or order. So these are the three essentials that a court will have to look into before applying its mind to a review application or a review petition. Firstly, a review lies to the same court which passed the order if the order is appealable and appeal is not preferred. Secondly, if the order is not appealable at all. And thirdly, from a decision on a reference from a court of small causes to the court which passed such order or decree. These are the basic essentials first when we think about a review. So firstly, there must be no appeal filed, even if an appeal is provided, and there must be no appeal provided at all, or from a decision or reference from a court of small causes. Now, the next criteria is given under, under order 47 of the Code of Civil Procedure. Under order 47 of the Code of Civil Procedure, the requisites of grounds available to an aggrieved person. The grounds available are different from the requisites. First, you qualify that you can seek a review. Then, whether you have grounds to seek a review. Now, what are the grounds to seek a review is different from qualification for a review. Qualification for a review, I repeat, that a review can be sought against an order from where no appeal lies, or if an appeal lies, an appeal has not been preferred, or from a reference from a small causes court. But grounds for review are different. Grounds for review are, again, there are three grounds. Now I have culled out the grounds in a simpler way. Otherwise I would be again reading the whole provision of law itself. I have culled out the ingredients required as grounds for a review petition. Now the ingredients are, now like I said, review is a very narrow remedy, limited by certain provisions where you can seek review only if you meet that criteria. The criteria is that when a petitioner, when a person aggrieved approaches a court which passed the order or decree, he must make out either of the three grounds. See, a review lies against an order passed by the court before the same court. So the grounds for assailing such an order before the same court are, because we would have already agitated the matter, the court would have heard the parties and then passed an order. Now, after an order has been passed by the court, we go to the same court and say, look here, these are the errors, these are the mistakes, this should not have happened, that should not have happened. But can all that be said in a general sense? Whether all that can be said, all that we feel is erroneous, can be brought before a court reviewing its own order, is the question. Now, the answer is that for a review, you can only go before the court which passed the order on 3 grounds. Just 3 grounds, out of which 2 are very important. The third one is akin to the first 2. The first ground is when an aggrieved person comes before the court which passed the order or decree and says, look here, I have new material, new evidence that I could not have adduced at the time of passing of the order. And I was not aware of this material. And I could not have with due diligence brought this material before the court when the order was passed. So therefore, this material is important to overturn or set aside or upset the order passed by the court. So the party who comes before the court gets new material or adduces new evidence which was not available to him at the time of passing of the order. Secondly, this is a very, very, very commonly used term when we think of a review. Error apparent. Now everybody says error apparent on the face of the record. Now, error apparent of the face of the record is another ground on the basis of which an aggrieved person can come before the court and say, see, there is an error apparent on the face of the record. So therefore, the order has to be reversed or the order has to be modified in such a fashion. Now, we will deal with what is error apparent on the face of the record, but basically, we must understand that an error apparent on the face of the record, when we use these words, it is not just any error. It is not just an erroneous decision of the court. It is an error which is visible first sight, which is visible as an obvious error, which is so striking that it is glaring from the order that there is an error. Such an error is an error apparent on the face of the record. Not all errors are errors apparent on the face of the record. Now, if one would go into the question as to what is error apparent on the face of the record, then there are several rulings. Again, people keep questioning that when this is error apparent on the face of the record in this case, why is it not error apparent on the face of the record in that case? Now, there are no comparisons. The error will manifest from the order, from the circumstances of that case. In certain cases, the court holds that such and such is an error. But in another case, that may not be an error apparent on the face of the record. So, error apparent on the face of the record, the test is, when you think of what is error apparent on the face of record, the test would be that there must not be a searching investigation required by the court or the person aggrieved to canvass a searching investigation into the error. If you go searching for an error, if you go investigating into an error, then that is not an error apparent on the face of the record. The error has to be obvious. The error has to be very clear. The error has to be visible at first sight. Such an error is an error apparent on the face of the record. Now, after these 2 requisites to seek a review, the grounds to seek a review, there is another ground. Any other sufficient reason. Now, when we say a review can be sought only on certain grounds, that is new material, error apparent, and then we generalize saying sufficient ground. Now, does it make it wide open to make out any sufficient ground and seek a review? The answer is no. The terms used as any sufficient reason have been a question before various courts, and the courts have said that any sufficient reason means it is a sufficient reason having nexus with the first 2 grounds, having nexus with new material now produced before the court or apparent error apparent on the face of the record. It is not just any sufficient reason, but it must have a clear nexus with either of the first two grounds to prefer a review petition. Now, a review petition can be preferred only on these three grounds. So one can imagine the narrow jurisdiction that a court dealing with review has to venture upon. Now, when we talk of the narrow jurisdiction, if we compare this jurisdiction to that of an appellate court. Now, I am told that you have been addressed on the question of appeals under the CPC by a very eminent personality. So I am sure you would have understood that section 96 deals with, of course, there are two appellate provisions in the CPC. Section 96 is the first appeal and section 100 as the second appeal. Second appeal again is limited to a question of law. But the first appeal under section 96 has a very wide scope. So when we compare the powers of a court under the provisions of section 114 or 47 to that of an appeal under section 96, it's a very narrow jurisdiction. In an appeal, the order of the subordinate court is assailable on all grounds. It is literally a rehearing of the case, reappreciation of the facts and law. It is actually, I mean, lawyers in common submissions before court say that appeal is continuation of the suit itself, the continuation of the original proceeding itself. So you can imagine the kind of scope that an appeal has. There are no fetters, there are no limitations, there are no boundaries. You can re-agitate the whole case from the original court, from the suit or other proceeding before the appellate court without any bar, without any kind of restrictions. But when you compare this with the jurisdiction of a review petition, jurisdiction of the court dealing with the review petition, then you will know that it's a very narrow jurisdiction. The court has to measure either of these three grounds being made out. And if any of them is made out, then only the court can proceed to allow a review petition. Now, what are the options available to the court in a review petition when it is reviewing its own order? The options available to the court are either to allow it or to dismiss it. We know that. But when a court finds none of these grounds in a review petition, then it cannot assume jurisdiction to correct any error, even if there is an error. Even if there is an error in its original order, it points out the error. But if it measures that error in view of these three grounds, that new evidence or new material produced before the court, which was not available to the petitioner, and the petitioner with due diligence at the time of passing of the order or decree was unable to produce it, or there is an error apparent on the face of the record, or any other sufficient reason, this is the measure. If the court finds against this scale that the order cannot be reviewed or upset or reversed or altered, then it will dismiss the review petition. Now, what are the requisites of allowing a review petition? That is also given under Order 47. Requisites of allowing a review petition are given in Order 47, Rule 4. The court, if it finds there is material and there is an error apparent on the face of the record, which is glaring from the order, from its order, which is under review, or the new material that has been produced appears to be material which if it were to have been produced at the time of the passing of the order, would have given a different meaning, would have weighed in favor of the aggrieved party or petitioner. Then the court can proceed to allow the petition. But again, there are limitations. The limitations are, again, they are given under Order 47, Rule 4. The limitations are that the reviewing court, before allowing a review petition, must issue notice and hear the other party before reversing the order under review. Because the other party will be aggrieved if the order is reversed, and the other party cannot be left to suffer without giving it an opportunity of being heard. So that is the first criteria. If the court wants or finds reason to review the order, then it must issue and hear the other party. Number two, the court must give a clear finding, must give a clear pointer towards error apparent on the face of the record. That either the error that is manifest from the order itself, or that the error has occasioned because the new material now produced was not available to the court and was not produced by the petitioner even after due diligence of the petitioner. So therefore, these are the two essentials before a court proceeds to review an order and allow the application for review, allow the petition for review. Now, in case the review petition does not merit being allowed or does not merit consideration, the court can dismiss it without issuance of notice. So there is no fetters on that. And once it is dismissed, there is no remedy available against the order of dismissal. On the other hand, if the court finds that the review must be allowed and it issues notice, then points out at the error apparent on the face of the record and allows the petition, allows the review, or reverses or upsets or in any way alters the original order that is brought before it for review, then an appeal lies against such an order. So when in a review, the review application is allowed and order or decree is reversed or set aside or modified, then the aggrieved person has a right of appeal. But if the review is dismissed, there is no remedy. Other than maybe the remedies under the Constitution before the High Court under Article 227 or before the Supreme Court under Article 136. But there are no remedies available within the CPC against an order of dismissal of a review petition. Against an order of allowing of a review petition, an appeal will lie to the next court, wherever the provision under the CPC provide for an appeal. Now, these are the basic requirements, and the provision itself calls out these requirements, and I have addressed those requirements and limitations for a question of review. If we have to go any further, and we may look at the case laws with regard to a review petition by various courts in various circumstances. Now, there are certain confusions that arise. Generally, when a review petition or when we speak of a review, like for example, what happens is anybody will feel when a court says a review is not allowed on a new plea, on a new ground, you can't prefer a review petition. Then the question obviously would be, when new material and new evidence will be new ground. Why shouldn't a review be allowed? Now we have to differentiate between new material and evidence and a totally new ground being agitated. Now, if a new ground is brought, what is a new ground? A new ground is something that was not agitated originally at the time of passing of the order or decree by the court. And after such passing of order, we realize, no, we should have urged this ground. Maybe this ground would have helped and the order could have been a little different. Such a ground is a new ground or a new plea. So such a new plea is not permissible. So we cannot confuse the new material or new evidence later on sought to be adduced in a review petition to be new ground or a new plea. New material or evidence must be only in support of already grounds urged in the original proceeding. A totally new ground and evidence in support of that new ground cannot be considered in the review jurisdiction. If the ground is urged, but material was not available, and that material is subsequently brought before the court in a review by the petitioner, and the petitioner says, I was not aware of this material. I only came to know subsequent to the passing of the order that there is this material which support my ground. And if he proves that it was not available to him even after due diligence, then the court may proceed to review the order. But to raise a new plea, to raise a new ground, and then produce material to support that new ground is impermissible. So therefore, there should be no confusion as to why courts say new pleas are not allowed in a review petition. New ground is not allowed in a review petition. Grounds that were available and urged before the original court at the time of passing of the original order and material that was not available is a ground. But new ground and new material is not a ground to seek a review. So therefore, new grounds and new pleas cannot be raised in a review petition seeking correction of the order. Now, correction of the order again. See, CPC has various provisions, inherent powers are there with the courts to deal with various orders in various fashions. Now, inherent power under section 151 is there. The court can, in the ends of justice, can do a lot of things which are not provided with under the CPC, but out of its urge to do justice, the court can use the provisions under 151, which is inherent power of the court to do justice between the parties for provisions which are not available in the CPC or even a quoting of a wrong provision. 151 CPC is oftenly used for as an inherent power to correct mistakes. Now, we could confuse the powers given under 152 CPC to order to section 114, that is review. The review jurisdiction is different from the powers of the court under section 152. Section 152 also provides for correction. Section 152 provides for modification. Section 152 provides for relooking, but only in case of mistakes, typographical errors, or errors of calculation, such errors, which are not touching the reasoning of the court, which are not touching the judicial mind of the court that has been used in passing the order. It is only to correct clerical mistakes that section 152 is used. There is, when we deal with the case laws, we will also come to that. Why I say that the review jurisdiction is different from 152 is because both are provided for correction of errors. But correction of errors under review jurisdiction is under these grounds that we have discussed. And section 152 deals only with clerical errors, errors which have come in due to typographical mistakes. Now we have a lot of errors coming up because of copy paste jobs. We have a lot of errors coming up due to inadvertence. So such errors are not errors apparent on the face of the record, as required under section 114 or Art 47. The corrections that are provided for under section 152 are corrections which both parties will agree when an application is made that this is a mistake, this is a clerical mistake, this is an obvious mistake which has been made because of wrong that has been done at the time of noting some figure or noting or calculating some number, things like that. So clerical mistakes are different from error apparent on the face of the record. That has to be very clearly differentiated. And there are attempts made, and courts take it very seriously, and they differentiate between section 152 and section 114 or Order 47. So there are attempts made to make the court believe that clerical mistake itself is a huge mistake and it will reverse the finding of the court. So 152 is also akin to review jurisdiction, but it is not so. They are two separate provisions made with a view to provide for correction of the court's own orders. Now, section 152 also applies to the court which has made that mistake, which has made that clerical or small mistake. But that does not mean it can assume jurisdiction under section 114 or Order 47 to correct such mistakes. Now, coming to the case laws, one more thing that can be dealt under Order 47 is that the court which passed the order alone can review. If a division bench has passed an order and a review is sought, then it has to be sought before the same bench. And if divergent findings are given by the two judges, then the review has to be rejected. Both the judges have to allow the petition. Then only the review can be allowed. Both the judges have to take a common stand and allow the review petition. If the two judges take divergent views, then the result is it can't be referred to another bench, but the review has to be dismissed. If it is to a bench larger than a division bench, then the majority in a review, if the order was passed by a bench having more than two judges, then the review will lie before the same bench and the majority ruling on the review will hold. So if the majority holds that the review has to be allowed, it can be allowed. Otherwise, it has to be dismissed. That is what is provided under Order 47, Rule 6 and 7. I mean, just to complete the provisions of Order 47. Then, adverting to the case law. Now, I have repeatedly used certain words and certain settled principles. Now, there are various rulings. I have, as far as possible, I have compiled judgments of the Supreme Court which deal with these questions as to what is error apparent and how an error apparent on the face of the record has to be viewed by a reviewing court. And in the absence of error apparent, can the court review its orders? Things like that. Now, error apparent could be lack of jurisdiction by the court, could be an error apparent. Now, for example, there is a case. There is a case of the Supreme Court before, judgment of the Supreme Court, wherein what happened was, here you can see it, it is at number 4. what happened there was a single judge dealt with an appeal which had to be actually posted before a division bench. A single judge passes an order and disposes of the appeal. Then before the Supreme Court, it is urged that the jurisdiction to deal with the appeal was with a division bench, and the single judge did not have powers to deal with the. Now that matter was urged before the single judge in a review petition. Single judge allowed the review, saying I did not have jurisdiction. This court did not have jurisdiction, and the jurisdiction was with the division bench. So that is an error apparent on the face of the record, which is very striking, which is very glaring, that a court did not have jurisdiction and assumed jurisdiction to dispose of the matter. So that is an error apparent on the face of it. Now, in the same judgment, their lordships have said that non-application of relevant statutory provisions also is an error apparent on the face of the record. Now, statutory provisions are very clear. Now, if a certain thing has to be done in a certain way, but the court by inadvertence or erroneously holds that the statute provides to do certain thing in a certain fashion, which actually the statute does not provide for, and a decision based on such the wrong assumption of a statutory provision can be reversed, and it can be termed as an error apparent on the face of the record. So again, the test is for an error apparent on the face of the record, for us to use that term in the sense or to read it as provided under Order 47 is that it must not be a mere mistake or a mere error. It must be an error which must be very obviously visible, without too much of probing or searching or investigating as to what is the error. The error must be apparent. That is why the word apparent is probably used. So adverting to the ruling reported in 2012 9 SCC 714, in a similar judgment in 2007 15 SCC 513, the court reviewing its own order, its own earlier order, if it reverses its order, and then it has to give a finding as to what was the error apparent. It can't simply say, yes, there was an error as required. I find there is an error and I am correcting it. It can't be. The court, see, the power under section 114 and order 47 is very, very restricted and has to be followed very strictly. Now the court, someone applies to the court saying, review this order, you have committed this mistake. Now the court may find that there is a mistake, but if it is not an error apparent, then it cannot reverse the finding, because there are other remedies against correction of errors, for correction of errors by way of review or appeal. Under the review jurisdiction, the error has to be an error apparent on the face of the record. It can't be just any mere error. And if the court allows a review petition, it has to point out what was the error apparent on the face of the record. And that is the reason why the order assailed or order impugned before it has to be altered or upset or reversed, and a review has to be allowed. So if a review has to be allowed, the court reviewing the order has to give a clear finding as to what was the error apparent on the face of the record. Rather than just saying there is an error apparent on the face of the record, the court will have to point out what was the error apparent on the face of the record. Now, like I said earlier, that if a review can be filed from an order which is appealable, But if an appeal is filed, the remedy of review goes away. But there are circumstances, overlapping circumstances, when a person prefers a review petition first. And also because the limitation is a question to prefer an appeal. So a person prefers a review petition first, then he prefers also an appeal. What happens in such circumstances? If the review petition is preferred earlier and the appeal is preferred later, then the review is maintainable. But again, there is a rider, there is a the ruling of the Supreme Court in AIR 1964, Supreme Court 1372, where the Supreme Court holds that if the review petition is filed earlier and the appeal is filed later, the review is maintainable, subject to the condition that the review is disposed of before the appeal is disposed of. So if the review is filed before the appeal is filed, then the review has to be disposed of before the appeal is disposed of. If the appeal is first disposed of, leaving the review petition pending, then the review petition becomes not maintainable. Because the appellate remedy is a bigger remedy. And that has been sought, and the appellate court, once it passes an order in the appeal, the review jurisdiction becomes infructuous. So therefore, again, to understand that appeal is a bigger relief, I think this judgment gives us a clear perspective of how narrow is the review jurisdiction. The review jurisdiction is provided for, the review can be preferred against an order which is appealable. But if an appeal is preferred and disposed of, then the review petition becomes infructuous, or the review petition becomes not maintainable. But nevertheless, if before the appeal is disposed of, review petition can be heard and disposed of, such an order would be maintainable. Again, against such an order, like I said, if it is allowed, an appeal lies to the aggrieved person. If it is dismissed anyhow, it makes no difference. The order survives. And similarly, the next case law, review jurisdiction is not an appeal in disguise. The mistake must be self-evident, need no search, and it must stare in the face to be error apparent. I've said enough about this. So I'll be going to the next judgment. The error need not be detected by process of reasoning, but must be glaring. The error must be apparent and not fish out or searched for. So again, I have said this, but not in these terms, but see, the words employed by the courts are so sharp that they make it very, very evident that just an error is not enough. It has to be an error which is very, very obvious, very, very glaring from the order itself, which is an error against which an order of review can be preferred. So therefore, why we advert to rulings of the courts is the way their lordships look at this and the sharp words that they use to interpret the law gives us a very clear picture as to what is an error apparent and what is the difference between a mere error and a patent error. A patent error alone is an error apparent and not just an erroneous view or an erroneous order. Now, adverting to next judgment, I have said a lot about this. Review jurisdiction is not as wide as to rehear the case as in an appeal. So a review court cannot rehear. It cannot say, okay, argue all the matter. I will review the whole judgment. I will review my whole order. The precision has to be maintained. The review court has narrow jurisdiction. It has to hear only on error apparent. It cannot hear parties over again, reappreciate evidence or the law over again. Then, if two views are possible, then it is no ground for entertaining a review petition. See again, In criminal law, we come across this, that if two views are possible, an acquittal must result. If there are two theories to the same set of facts connecting to the accused person, if two theories are possible about the offense committed, then the accused must be given the benefit of doubt. But that is a different thing. Here, though it is similar, what happens is, if two views are possible, that means there could be an error. There is a doubt whether there is an error or not. In such circumstances, a review will not lie. Just because there is an error or just because there are two views possible, a review will not lie. Again, a review has to be looked at with the precision of the provision itself. The provision says error apparent. Error apparent means something very glaring. Not when we go look at two possible views, we are going searching. That is not permissible. We are not going searching in a review petition. We have to stick to the grounds that there must be an error apparent, and an error apparent, error apparent could be in different cases, various things. There are still judgments to come and decide what an error apparent could be. But the principles are, basic principles are, the error apparent must be an error which must manifest itself from the order, and we must not go searching for it. And if we search or investigate, then we are out of the review jurisdiction. Then we are not entitled to maintain a petition in the review jurisdiction. And mere erroneous decision is not an error apparent. There is a very beautiful judgment reported in 2013 8 SCC 320, which will encompass all that I have said and more, which is a complete code, which will say what are the requirements of a review petition. So I have not said much about that in the slide. All I say is principles of entertaining a review petition. There are all these principles have been enumerated and more. The explanations are so precise that you will find it a good lesson on review petitions. Then again, re-arguing or re-agitating questions addressed and decided are not permissible. I have already my learning comes from these judgments itself. So this is a judgment which will dwell with the question, what is rehearing or re-agitating? So rehearing or re-agitating is something that we do in an appeal and not permissible, or maybe a bit in the revision, but not in a review petition. No new ground can be urged. Only new material evidence which was not available and adduced is permissible. Now I have brought about, like I said, people raise questions. Why no new material? Why no new grounds can be raised when new material can be produced? I have already said that new material which was not available on the grounds already urged before the original order was passed. Grounds are urged, but there was some material which the petitioner could not produce at that time. So that is permissible, to adduce new evidence on grounds that were urged before the original order was passed. But new grounds cannot be urged in a review petition. Now, the question of what is sufficient reason. There are three grounds: new material, error apparent, and any other sufficient reason. So when we say any other sufficient reason, it is not again wide open that any sufficient reason. So the courts have held, there are several rulings, but in these two rulings, what I found was the courts have said they have to be analogous to the first two grounds. That is, production of new evidence or material and error apparent on the face of the record. Sufficient reason in Order 47 means it must be analogous. There must be some nexus between that reason and the first two. that is error apparent or new material that was not available to the petitioner at the time of passing of the order. So this will clarify how the third ground under which the review could be preferred before a court of law. Then an application for review cannot be entertained in the name of modification, clarification, or correction of the order. And the next one is section 152 CPC, where there is a judgment of the court which deals with these two aspects itself, which deals with what is the difference between powers under 152 and powers under 114 and order 47. So there is a differentiation brought out by these judgments in the garb of seeking clarification, in the garb of seeking modification or correction of an order. One cannot enter into the review jurisdiction. One cannot seek review of the order. That has been dealt with by these two judgments. So the remedy against allowing of a review petition, I have said, is by way of an appeal. Against rejection, there is no remedy. If a review petition is rejected, no remedy will lie to any other court against such an order. That becomes final. That becomes final. Again, it becomes final under the code. The powers of the High Court under Article 226, 227 or Supreme Court under Article 136 are different. They are not within the Civil Procedure Code. So a person aggrieved by an order of dismissal of a review may seek recourse under those provisions under the Constitution of India. Now, I will proceed to the provision of revision under section 115 of the Code of Civil Procedure. Now see again, these are provisions which will, if we read them or understand them or speak about them in one go, may create a bit of confusion. But believe me, there is no overlapping jurisdiction. There is absolutely, they are distinct reliefs. They are absolutely different from each other. And there has nothing to do, they don't have anything to do with each other at any point of time. They are two parallel remedies. I mean, not even parallel, they are two completely distinct remedies under different circumstances. They are not remedies which overlap or go hand in hand at any point of time. They are remedies in different circumstances. Review under different circumstances, revision under different circumstances. Now, 115 of the Code of Civil Procedure deals with what is a revision. What orders can be questioned by a revision petition. Now, like I already said, review and revision are remedies that have to be provided by a statute. No court or authority can assume revisional jurisdiction or review jurisdiction of review without there being a provision in the statute. Now, for example, a khata is issued under the Municipal Corporations Act. The authority issuing khata does not have powers to review and withdraw the khata with respect to a property, because it is not provided for. Under the statute, the power to review is not provided. So power to review and power to revise or power of revision has to be provided in a statute for a court to exercise such powers. So now Civil Procedure Code provides for both and more. It also provides for an appeal. It also provides for a second appeal. So Generally, the appeals are under a wider jurisdiction. The appeal, when provided for and when not restricted by the statute itself, is a very open remedy, is a full remedy. It's a rehearing of the original proceeding, unless it is restricted. Restricted in the sense, now CPC itself, the Code of Civil Procedure itself restricts under section 100, a second appeal to be heard only on a question of law. A court sitting in a second appeal under the Code of Civil Procedure will hear only on a question of law. It will not hear parties for reappreciation of evidence. Everything is not open before a second appellate court under section 100. So there is a restriction. But section 96 is not so. I have already stated. And section 96 is probably a very wide open remedy provided against judgments and decrees of various courts. They may lie to either subordinate courts or high court, depending on the pecuniary jurisdiction. But a revision is a very special remedy. A revision is a remedy. A revision is a power given to the high court to correct mistakes committed by courts subordinate to that high court. So a high court has jurisdiction under section 115 of the Code of Civil Procedure to sit in revision over orders of its subordinate courts. So high court cannot, high court has subordinate courts within the state, under it. So those subordinate courts, if they pass any order, the high court has revisional jurisdiction to deal with. So the difference between a review and a revision is one of this, that review has to be filed before the same court that passed the order. But a revision lies only to the high court. It does not lie to any other court. It lies only to the high court. An appeal can lie to a subordinate court also, from a judgment and decree of a subordinate court to one other subordinate court. But a revision lies only to the high court under section 115 of the CPC. But again, though revisional jurisdiction is a part of appellate jurisdiction, it is not an appeal. It is not as wide as an appeal. Now, revisional jurisdiction is further restricted. Now, section 115 was recourse to correction of various orders of subordinate courts. Almost all orders of subordinate courts till the 2002 amendment to the Code of Civil Procedure. Once the amendment came in, it brought certain restrictions. Not all orders could be challenged before the High Court in a revision. So what are the requisites? What order could be challenged before the High Court in a revision? Now, the High Court also has suo motu powers, or a person aggrieved can approach the High Court under the revisional jurisdiction. Now, see, there is another thing going a little forward, which may not be too important, but what happens is the word used in an appeal is a person aggrieved can approach the appellate court. Now the courts have gone on to say a person aggrieved can be a person who need not be a party to the proceeding. If he is aggrieved by that judgment and decree and he is not a party to that proceeding, even then he can prefer an appeal. So that is the power of appeal. A person aggrieved who is not a party to the original proceeding can go and file an appeal. If he is aggrieved and if he shows that I am aggrieved by this judgment, though I am not a party, it transgresses my rights, it affects my rights, then he can prefer an appeal. But revision and review are restricted remedies where if a person is not a party to the original proceeding, he has no locus standi to question that before a court of review or before the revisional court. That is a basic difference. That is how wide the relief of appeal is. That is how wide the appellate jurisdiction is. Now the revisional jurisdiction has been cut down. The revisional jurisdiction has been cut down with certain limitations. Now these are the limitations. By way of amendment, in 2002, the Code of Civil Procedure has been amended, and by way of amendment, there have been certain changes brought to the. Come back to this. See, the High Court in a revision can sit in revision over an order of a subordinate court, and a revision lies to the High Court on 3 grounds. That the subordinate court, while passing the order, exercised jurisdiction not vested in it. Number 2, it did not exercise jurisdiction that was vested in it, or it exercised jurisdiction but with illegality and material irregularity. So there are 3 circumstances. 1, it did not exercise jurisdiction vested in it. 2, it exercised jurisdiction not vested in it. 3, it exercised jurisdiction but with material irregularity or illegality. Against these 3, only such orders can be questioned in revision. So the High Court firstly will look at these 3. If a case is decided and the court has exercised jurisdiction not vested in it, or not exercised jurisdiction vested in it, or acted within a jurisdiction with illegality or material irregularity, then it assumes jurisdiction under the revisional jurisdiction. But the 2002 amendment brought these restrictions. This first restriction, the limitation that it creates for seeking a revision of an order before the court, is that suppose an order has been passed and we have to seek a review of that order, then the condition would be that if that order is reversed in favor of the petitioner, then it should have disposed of the original suit or proceeding itself. Now a revision lies only against an order where, if the order is reversed in favor of the revisional petitioner, and if reversed, that order were to dispose of the suit or proceeding. For example, a suit is filed by a partnership firm. The defendant, for recovery of money, the defendant comes up before the court and files an application for rejection of the claim, saying under section 69 of the Indian Partnership Act, the plaintiff firm is not a registered firm under the Partnership Act. So therefore, the plaint has to be rejected, as it is a bar under section 69 for an unregistered firm to file a suit against a third party. Now, if that application is rejected, suit survives. If that application is allowed, a dismissal follows. And if a dismissal follows, it's a decree. A dismissal of a suit is also a decree. But if that application is rejected, then the remedy of revision arises. Because if reversed, if the revisional court reverses that finding and says, yes, the suit is not maintainable because it is barred under section 69 of Indian Partnership Act, if it were to say that, then the proceeding entire suit will get disposed of. So there is a fiction that if the order were to be reversed in favor of the petitioner, if the order were to be reversed in favor of the petitioner, then it should dispose of the suit. Only then a revision will lie. So this condition was brought in by the amendment. Before that, it was not so. Before that, any jurisdictional error or acting or an act of the court in an order with material irregularity or illegality could have been questioned. So we used to file a civil revision petition against allowing of an application for amendment under Order 6 Rule 17, or against dismissal of an application under Order 6 Rule 17, application under Order 1 Rule 10 2 for impleading some party, either allowed or dismissed. We used to file. But today the restriction is, if the order that we are questioning before the revisional court, if reversed, it has to dispose of the suit. Otherwise, you can't prefer a revision petition. That is the amendment that has been brought. Then the second limitation is that an appeal must not lie from such an order. Now we have Order 43. Order 43 prescribes for appeals from certain orders of the court under various provisions, like under Order 39, Rule 1 and 2. If an application is allowed or dismissed, an appeal lies to the court, not a revision. And that appeal is a miscellaneous appeal. We don't make it an appeal under Order 41. It's an appeal under Order 43. So there are certain appeals that are provided for from orders of the court, which amount to a decree. Those orders amount to a decree, and an appeal lies against those. So if an appeal lies, then a revision will not lie. As against in a review petition, if an appeal lies and it is not preferred, we can prefer a review petition. And if an appeal does not lie also, we can prefer a review petition. But under the revisional provision, under section 115, if an appeal lies to the High Court or to any other subordinate court against the order impugned in the revision, then the revision will not be maintainable. The revision will have to be dismissed. And thirdly, there is one provision which says a filing of a revision alone will not operate as a stay of the suit. Now, probably this provision is to make it clear that mere filing of a revision petition will not amount to stay of proceedings of the suit. Now, there is a similar provision under Section 34 of Arbitration Act. Earlier, mere filing of Section 34, an arbitration suit under Section 34 amounted to stay of the award. Now, an amendment in 2015 has made it. Made it very clear and incumbent on the party seeking recourse against the award or an arbitral award to seek a stay of that award separately. Mere filing of Section 34 arbitration suit will not amount to stay of the award automatically. So similarly, to avoid a feeling that seeking a revision before the High Court will lead to automatic stay of the proceedings of the suit should not be construed. Mere filing of a revision petition will not amount to stay of the proceedings of the suit. Now, therefore, just to sum up the revisional jurisdiction of the High Court, it is only the High Court which can assume the revisional jurisdiction against the orders of the subordinate courts. It is a part of the appellate jurisdiction. It is only a part of the appellate jurisdiction. It is not the appellate jurisdiction itself. Or we should not confuse that revision is a part of appellate jurisdiction, so appellate jurisdiction is also a part of revision. No, vice versa is not correct. Revision is a part of the appellate jurisdiction. It lies only to the High Court from the orders of the subordinate court. The three conditions under which it lies is, number one, the order impugned must have been passed by the court, subordinate court, with a jurisdictional error where it should have passed the order in excess of its jurisdiction, or failed to exercise jurisdiction vested in it, or it should have passed an order with material irregularity or illegality, although within jurisdiction. So these are the three requisites, essential requisites. The limitations are that if the order impugned were to reverse, if the order impugned is reversed in favor of the petitioner, then it should dispose of the suit itself. Otherwise, a revision will not lie against an order. Though it may satisfy the other three criteria, excess of jurisdiction, non-exercise of jurisdiction, or illegality or material irregularity or illegality. But if it does not satisfy this criteria, this limitation, then a revision will not lie. Then, if an appeal lies, a revision does not lie. The appeal may lie either to any other subordinate court or the High Court. If an appeal lies from an order which is sought to be questioned in a revision, then the revision will not lie, because it is a part of the appellate jurisdiction. Revision is a part of the appellate jurisdiction, and appeal is a bigger remedy. So if an appeal lies, the revision will not lie. And thirdly, that mere filing of a revision petition under section 115 will not amount to stay of the suit, stay of the proceedings in the suit. So this is what we can cull out from the provisions under 100 section 115 section 115 of the CPC. Now there are other issues that will arise in a revisional jurisdiction. Now we have time and again said it is a narrower jurisdiction than the appeal. So obviously reappreciation of evidence, reappreciation of the law is not permissible. It has to be only again with the scale, excessive jurisdiction or lack of exercise of jurisdiction, or material irregularity or illegality in exercise of jurisdiction. Apart from this, there no other thing can be looked into. Then only parties to the proceeding can invoke revisional jurisdiction. Like I said, aggrieved person, even if he is not a party to the suit, can file an appeal with the leave of the court, but a revision can't be done like that. He has no locus standi if he is not a party to the proceeding in which the order is passed, which he wants to question before a revisional court. So a revisional court can only entertain a petition questioning the order of any subordinate court where from a party to that proceeding. A non-party will not have locus standi to seek a revision of the order of the subordinate court. High Court cannot see this will be a very important thing. 3 and 4 case laws that have been discussed. High Court cannot correct error of fact in case of, especially in case of concurrent findings. Then it cannot reappreciate evidence. Then there are judgments which will say, yes, it can do. Yes, it can enter into facts. It can reappreciate facts. But again, the courts dwell into the facts only in certain circumstances, only with a view to do justice, only if an order passed by the subordinate court is perverse. It is the finding given is one and the relief given is another. Now the finding is in favor of the petitioner, but his application is rejected. Then the High Court will not restrict itself to this settled principle that reappreciation of evidence is not allowed, then the High Court will go a step further and reappreciate evidence, because there is perversity, there is some glaring mistake committed by the court below with regard to the facts of the case and to the relief granted. So there is one judgment of the Supreme Court reported in 2019-16 SEC page 1. Under what circumstances finding of fact can be interfered by High Court in revision? So this is a case where the High Court entered into the facts, reappreciated the facts, and granted a relief under the revision jurisdiction. And why it did, there are clear principles for that. Not in every case that the High Court can enter into the facts or the question of law unless these conditions are satisfied. These conditions are the finding without consideration of material evidence or misreading of evidence which is grossly erroneous and would result in miscarriage of justice. So if evidence is misread, or if the evidence is considered in a wrong fashion by the subordinate court, then in a revision, and that it is not just that it has been considered, it has been misread, but it must lead to miscarriage of justice. The result of such misreading, the result of non-consideration of material evidence, which leads to miscarriage of justice, then the High Court in revision can reappreciate evidence or enter into the evidence that has been considered by the court below. Then, in this case again, what happened was, see, the general principle of standard of proof in civil courts is preponderance of probability. So what is more probable, the court has to look into. That is the measure for deciding civil disputes. Unlike in criminal cases where, like I said earlier, if two theories are possible, then acquittal must result. So benefit of doubt must be given to the accused. So the principle in criminal cases is that you have to prove the guilt beyond reasonable doubt. Whereas in civil cases, it is preponderance of probability. So if 2 or 3 theories are possible, what is the most probable? The court has to, that is the measure of proof in civil suits. So if the court has failed to apply that measure, the principles of standard of proof in civil suits, that is preponderance of probability, then in such circumstances, a revisional court, that is the High Court under sitting as a revisional court, can reappreciate evidence. So there are very, very limited number of cases that you will find where the High Court has thought it necessary to appreciate evidence or consider evidence. Otherwise, the courts under section 115 will not go into the question of reappreciation of evidence under the revisional jurisdiction. Because again, the revisional jurisdiction is a creation of statute. The statute provides and limits the powers of a revisional court. So the courts have to act within those limitations when they sit as revisional courts. Now, what is the remedy? I mean, one would ask, what is the remedy? If there is, I don't qualify to the limitations of section 115, but I have an erroneous order from a court, subordinate court. What is the remedy? What do? I don't have an appeal. There is no appeal provided. There is no other recourse. Then it is settled now that when there is no other recourse available, then the jurisdiction of the High Court under Article 227, the supervisory jurisdiction of the High Court, the aggrieved person can approach the High Court in a writ proceeding, questioning any other order which otherwise would not be maintainable as in a revision. So such orders can be questioned by way of a writ petition under Article 227, the supervisory jurisdiction of the High Court. Now, conditions for exercise of power, like I cited one ruling for the review, a similar ruling which deals with what is a revision, which is again a lesson. The Supreme Court has enumerated how a revision has to be treated, and academically this judgment will call out requirements of preferring a revision petition before the High Court under Section 115. What are the requisites? What are the powers that that can be exercised, and conditions for exercise of powers of revision? That is again, it must be a decision from the subordinate court only to the High Court. There must be a case decided by subordinate court. There must be error in jurisdiction or exercise of jurisdiction illegally or with material irregularity. So the court has dealt with what are all these requirements. Merely saying what is material irregularity or illegality without going into the question what it really means. What is excessive exercise of jurisdiction or what is lack of exercise of jurisdiction has been dealt with in this. Like I have repeatedly said, more than required. There is one judgment which deals with that the difference between an appeal and a revision, the appellate jurisdiction and the revisional jurisdiction. I have already, I have said that only after reading these judgments. So I'm only giving you the citation, 1989 1 SEC, page 19. Then, order in revision must be a reasoned order. Now, that is why we say that revision is a part of the appellate jurisdiction. Revision is a part of the appellate jurisdiction. Now, in an appeal, when an appeal is provided under a statute, the appellate court must reason out its findings. It can't merely say allowed, dismissed. It can't simply pronounce judgment without giving findings. So similarly, the advantage of the revisional jurisdiction as against other remedies available is that the court will reason out why you are entitled to a relief under revision or why you are not entitled to a relief under revisional provision under Section 115. So the Supreme Court had an occasion to address this as to whether an order passed by a revisional court, that is a High Court, has to be reasoned, whether an order must advert to merits of the case or merely give a finding that it is allowed or dismissed. So the Supreme Court said, no, it has to be a reasoned order. And a reasoned order, the advantage is when there is a reasoned order, a person who wants to assail it or question it, if he is aggrieved by it, can find reason why it is wrong or point out mistakes in it if it is reasoned. So therefore, the advantage of Section 115 is that if a person approaches the High Court under the revisional jurisdiction, the High Courts will reason out whether they allow the revision or reject the revision. They will reason out why they pass any order in whatever fashion they may pass. And revisional jurisdiction in effect is and substance appellate jurisdiction. This I have time and again I have adverted to that. Then a revisional jurisdiction, in the revisional jurisdiction, principles of natural justice have to be, of course, principles of natural justice have to be followed by any judicial authority or a quasi-judicial authority. It has to follow principles of natural justice. So obviously, this being the High Court having the powers of revisional jurisdiction, it will have to issue notice if it has to upset the order. It will have to issue notice to the respondent or the other side if it has to reverse the finding. If it has to dismiss the petition, it can dismiss it even without issuing notice to the other side. But if it has to allow the revision, then it will have to issue notice, hear the other side, and then proceed to pass an order. Now, what is jurisdictional error? What is jurisdictional error? I mean, we keep on saying that excess of jurisdiction or lack of jurisdiction or acting within jurisdiction but with material irregularity or illegality. These are the words we keep using when we come across the revision jurisdiction. But this judgment 2009 5 SCC 162 makes it clear as to what is a jurisdictional error. A jurisdictional error goes to the root of, see, there is one judgment of Honorable Justice Arvind Kumar of Karnataka High Court. I have this thing. When I was compiling material, I read his lordship says we are not looking into what is the order in a revision. We are not looking into what is the order. We are looking into the question how the order was made. So a jurisdictional error arises when you look into the question. I mean, you can point out a jurisdictional error when you see how an order has been made, on what basis the order has been made. Instead of looking at just the reasoning, on what basis the order has been made. So a jurisdictional error is again those three requirements under section 115 with regard to lack of jurisdiction, exercise of excessive jurisdiction, or exercise jurisdiction with material irregularity or illegality. So this judgment gives us a clear understanding of more than what I say. Of course, again, I say what I have said is what I have learned from these judgments and various other judgments. But this judgment goes into the question as to what is a jurisdictional error in depth. That is why I am requesting everybody to have a look at this judgment. It will throw light on the question what is jurisdictional error. Then again, I have already said and that where a revision will not lie due to the limitations, if the revision does not lie, then the person aggrieved can invoke the jurisdiction of the High Court under Article 227, the supervisory jurisdiction of the High Court. That is, I mean, there are several judgments. I have just cited two of them where it is very clear that where a person wants to question the order of any subordinate court but does not have any recourse. When the person does not have any recourse, he can approach the High Court under Article 227, the supervisory jurisdiction. There is one judgment. I mean, I have avoided reading through the judgments. That is why I have made the slide so that it is precise. Otherwise, we would be reading too much and reading over the screen. I mean, it won't be a very comfortable thing. But I would like to read from a judgment, only one judgment, which is a judgment of the Supreme Court with a bench strength of 5 judges. So all I have said, I need not have said. I could have told you read this judgment to know what is revision. It completely sets at rest our doubts about the revisional jurisdiction, about the appellate jurisdiction. In a few words, that is why I said the precision with which judges use these words is, it gives so much clarity. And how that happens probably is because we ask for doubts, we ask, we question, and when the answers come, and in this judgment the answer is so precise, so clear, and it is, I mean, it's again a lesson on what is revision and what is appellate jurisdiction, what is revisional jurisdiction. This is a judgment reported in 2014, volume 9 Supreme Court cases, page 78, where their lordships at paragraph 28, I will just read this, though it is a little thing, but I feel that this will sum up my entire talk today, and it will really go a little beyond my own research. It will go a little beyond my own capacity to have understood these provisions. At paragraph 28, their lordships say, conceptually, revisional jurisdiction is a part of appellate jurisdiction, but it is not vice versa. Both appellate jurisdiction and revisional jurisdiction are creatures of statutes. No party to the proceeding has an inherent right of appeal or revision. An appeal is continuation of suit or original proceeding, as the case may be. The power of the appellate court is coextensive with that of the trial court. Ordinarily, appellate jurisdiction involves rehearing on facts and law, but such jurisdiction may be limited by the statute itself that provides for the appellate jurisdiction. On the other hand, revisional jurisdiction, though is a part of appellate jurisdiction, but ordinarily it cannot be equated with that of a full-fledged appeal. In other words, revision is not continuation of suit or of original proceeding. When the aid of revisional court is invoked on the revisional side, it can interfere within the permissible parameters provided in the statute. It goes without saying that if a revision is provided against an order passed by tribunal appellate authority, the decision of revisional court is the operative decision in law. As regards the extension of appellate or revisional jurisdiction, extent of appellate or revisional jurisdiction, much would, however, depend on the language employed by the statute conferring appellate jurisdiction and revisional jurisdiction. A few sentences more at paragraph 31, where both expressions appeal and revision are employed, where both expressions appeal and revision are employed in a statute. Obviously, the expression revision is meant to convey the idea of a much narrower jurisdiction than that conveyed by the expression appeal. The use of two terms, appeal and revision, when used in one statute conferring appellate and revisional power, is not without purpose and significance. Originally, same statute provides the remedy by way of an appeal and so also of a revision. If that were so, the revisional power would become coextensive with that of the trial court of the subordinate tribunal, which is never the case. In the garb of revisional jurisdiction, under the above three rent control statutes, the High Court is not conferred a status of second court of first appeal, and the High Court should not enlarge the scope of revisional jurisdiction to that extent. Therefore, an appeal and revision, if they are provided for in the same statute, the obvious deduction, obviously what can be deduced is that the appellate jurisdiction is wider and the revisional jurisdiction is narrower. And a court having revisional jurisdiction cannot assume the powers of an appellate court. It has to work within the restrictions and limitations prescribed by the statute itself. Otherwise, it would be exceeding its jurisdiction. Their lordships have, in fact, this judgment has been followed in another judgment of 2019. I have cited it earlier, where, of course, this judgment has been thoroughly this thing, but there, this judgment has become operational. 2019 9 SEC 282. His Lordship Justice Mohan Shantan Gowda has applied the principles laid down in this judgment of 2014 of the Supreme Court, which had a bench strength of 5 judges. And this judgment is also a classic because it applies to the facts and circumstances in that case, this judgment, in a very appropriate manner. So therefore, I conclude that there is much more to come. The pronouncements are there. We will always have newer interpretations. What is error apparent on the face of the record? We will have several pronouncements in future also. And what is jurisdictional error? We will have several pronouncements with this also. So in the end, what happens is we will have to only employ the language used in the statute as far as possible to interpret these terms depending on circumstances and facts of each and every case. I have made my best attempt to put it across to all of you. I don't know how much it has been helpful, but I have made my best attempt. Hopefully it will benefit some of you. I again thank you all for giving me this opportunity to be addressing you on these 2 issues. I thank you. I conclude my talk. If there are any questions, I would be happy to take.
If you're okay, if time permits, can we ask you a few questions?
Oh, go ahead. Please go ahead. Please go ahead.
Our students have liked it so much that there is a barrage of questions. I'm trying to limit it to a few questions. I hope it's okay.
Oh, I can. I have complete time. Today we are not working, so I am completely free.
So the first question is,
Yes.
whether there is an overlap between writ jurisdiction and application for review and revision. So in the sense they want to ask, let's say, is there an option for the party to go for a writ of certiorari or prohibition, or at the same time, instead of review or revision?
No, there is absolutely no overlap. See, there cannot be an overlap. See, as far as review is concerned, there cannot be an overlap because review lies to the same court which passed the original order. Whereas a revision lies only to the High Court from an order of a subordinate court. Now, to avail the remedy under 115, if you do not have the requisite qualification, firstly, error of jurisdiction and exercise of jurisdiction with illegality or material irregularity, then the amendment in section in 2002, it brings in a rider that if you have to enter into the, if you have to make an application or a petition to the High Court under section 115, then if the order that you are challenging in revision were to be reversed, it must have disposed of the original proceeding completely. So it will be a question of maintainability, which has been answered in the negative. That the court below would have generally said the proceeding is maintainable, application is not maintainable. Only such orders you can question in section 115. So once you you don't satisfy these criteria, only then, you see, what happens is writ jurisdiction is available when no other remedy is provided for. So there's no question of there being any overlapping of revisional jurisdiction or the writ jurisdiction. Of course, the prayers will be setting aside, like you said, the prayers will be setting aside of the orders. The prayers could be that. I mean, the kind of writ you file depends on the kind of order you are challenging. And even in a revision petition, you seek setting aside of, but that is not the criteria. The criteria is what kind of order you are challenging. If you qualify to file a revision, only you can file a revision. And if you fail to qualify, your remedy is to go before the court under Article 227 of the Constitution.
So the second question is with respect to the point that because error apparent, there is no objective criteria for the courts to determine what an error apparent is. Is there an element of arbitrariness introduced because of which dispensation of justice we could say that it is going haywire?
No. See, we cannot say that it is the terms error apparent or arbitrary. There are, I mean, see, again, interpretation of these words in various ways by various courts has settled the position that error apparent means a very obvious error. Now, like I said, in one of the judgments, the error was that the appeal would lie to a division bench of the High Court, but the appeal was disposed of by a single judge. Now, appeals before the High Court lie to single judges as well as to division benches based on the pecuniary jurisdiction. So if an appeal that, or there are statutory provisions. If the statutory provision provides that the appeal must lie to the division bench, then it lies to the division bench. But if such an appeal is brought before a single judge and by inadvertence, the single judge passes an order and disposes of the appeal, and later on in revision, it is brought to the notice of the court. In review, it is brought to the notice of the court that the court did not have jurisdiction. The jurisdiction to dispose of that appeal was with the division bench. And it is an error apparent. It is an error which is glaring. It is an error. See, again, error apparent has a huge, it's not a mere error. Otherwise, the statute would have used just the word error. Then it would become arbitrary. Then we would not know where to go. What is the recourse? To which court to approach? But here, the word used is error apparent on the face of the record. So it has to be an obvious error, a glaring error, an error which need not be searched for, an error which need not have to be found on reasoning, an error which need not be investigated to reach it. So such an error. So it is not, see, judicial discretion and application of judicial mind in view of words used in the statute would always decide what is error apparent. And it may look very arbitrary to a layman, but people, I mean, for judges and lawyers who deal with these provisions, I think we have more or less a very settled position as to what is error apparent on the face of the record. So to say that it gives an arbitrary meaning and it is very fluid. No, it is not fluid. It is pretty concrete now as to what is an error apparent on the face of the record. But again, to decide that this is error apparent and that is not error apparent will not be possible. The error apparent in each case will arise in facts and circumstances of that case. That is why I said there will be pronouncements in future also, which we don't know. They may interpret error apparent in a different way. But whatever be the way they interpret, the basic principles of deciding what is error apparent is that it has to be apparent. It has to be a patent error. It has to be a clear, obvious error. So I don't think it is arbitrary, but definitely that question is asked very often, and I mean even we lawyers ask that question very often. So, but nevertheless, I don't think it is so.
So second, this is an interesting question probably. Now they're asking, once a decision is given on a review petition, once an order is passed, well, first of all, is that order appealable? And while contesting in an appeal, can you try to make it one more appeal?
See, let's go back again. I mean, I will give you an instance also later on. See, an order 47 rule 4, I think 4 and 4 deals with how to deal with a review petition, how the court has to deal with a review petition. Now the court has to deal with a review petition either to allow it or reject it. Now for it to reject it, there is no criteria. It can say, I don't see any of the ingredients required, any of the grounds required. It doesn't appeal to me that there is an error apparent on the face of the record. Generally, we take that kind of orders more. but what happens is, an error apparent on the face of the record or the new material that is brought before the court, if the court does not find any of it to be good enough to reverse its original order, then it can reject it, saying so, that I don't find, that the court does not find any error apparent on the face of the record, and that the court does not find that the material that has, the new material or evidence that has been now adduced was not available to the party at that time. But the problem arises when the review petition has to be allowed. Now, what is the criteria? The criteria is, when the review petition has to be allowed, it is given under Order 47 Rule 4, where it appears to the court that there is not sufficient ground for review, it shall reject the application. So it will reject the application. But application where granted, that is subsection 2 of Rule 4, sub-rule 2 of Rule 4, where the court is of opinion that application for review should be granted, it shall grant the same. Two conditions have to be fulfilled. One, before granting, the court has to issue notice to the other side. It has to hear the other side, because if it is granting, no order can be passed without hearing the other party. Principles of natural justice. And second criteria is, the court shall have to give a finding that certain error that has crept into the order and in review is an error apparent. It has to give a finding that such and such an error is an error apparent on the face of the record. These two conditions, if they are satisfied, an application for review can be allowed. Now, coming to the second part of the question, that what is the recourse? The recourse on rejection of review, there is no recourse. There is no appeal that lies. There is no revision that lies from such an order. But if the application is allowed, for review, and the original order is modified or set aside or altered, then the aggrieved party has an option of appeal. Now, to which court the appeal lies will depend on which court has passed the order. The hierarchy works there, and the provisions for appeal will apply. Now, there's one more confusion which we come across. See what happens when there is no recourse. We go under Article 227 is what I have said. So, maybe when an order of review is rejected, Because there is a supervisory jurisdiction of the High Court, maybe you can prefer a writ petition. But otherwise, within the statute, within the framework of the Code of Civil Procedure, there is no recourse to a person who has filed an application for review and his application has been rejected.
Okay, sir. I will probably end with this a lighter question. So the person is asking, then should we do away with review and revision petitions only? Is there necessity, or like CPC is too much of provisions? These are all useless, is what I say. We should streamline
For
everything.
God's sake, don't do it. Lawyers make a living of this. No, they are very important provisions. See, Code of Civil Procedure, a lot of people have a wrong feeling. I have heard Justice, His Lordship Justice Venugopal Gowda and His Lordship Justice N. Kumar and several other prominent speakers in various webinars of late. See, they have said, in fact, Justice N. Kumar and Justice Venugopal Gowda have gone to an extent of saying that you don't know how to use it. They have told lawyers, you don't know how to use the CPC. The CPC is not creating problems. The Civil Procedure Code is a very, 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 very widely provided code which has provisions and recourses for everything. It is only that our understanding and our way of using the code that is defective. So to say that revision and review are useless provisions or any provision in the CPC is not so. It is a code that has survived from 1908. It is not properly put into action, and probably we lawyers are, at least 50% responsible for that. And see, what happens is, over a period of time, things have settled down. The courts have interpreted the law. We are now in a better position to understand the code. And moreover, the courts have clearly held that the procedure is only a handmaid. It is not it's only a mistress, not the queen. So it is not important that the procedure has to be strictly followed, but nevertheless, the procedure gives you the discipline to give way to the enforcement of law and rendering justice. So Civil Procedure Code is a very, very detailed code. It is not followed just by us, it is followed by various other countries also in different forms. The Civil Procedure Code is not, it is not that it is causing or hindering speed in delivery of justice in civil courts. There are other issues. We may have to have another forum to talk on the delays and requirements, maybe to change a bit of the provisions there, but definitely we can't do away with these provisions.
Thanks a lot, sir. Shiraja, over to you.
Thank you, Mr. Yeshu Mishra, for your lucid and brilliant discourse on reviews and revision. I now request our Assistant Professor, Prasadji Hiremat, to deliver the vote of thanks.
Thank you, Sriraja. Good morning, one and all. I deem it an honor and privilege to render vote of thanks on this fifth part of the lecture series on civil litigation organized by KLE Society's Law College, Bengaluru. First and foremost, I thank Honorable Guest Speaker Shri Yeshu Mishra, Advocate and Partner, Harnally Law Partners LLP, who happily obliged our request to speak in this series and enlightened us with his vast experiential knowledge on the topic. And we look forward to have many more such sessions in the days to come. I owe special gratitude to respected Principal Shri J. Mallikarjunaya sir and IQAC Coordinator Shri Manoj Kumar Hiremat sir for their kind cooperation and encouragement which made this webinar materialize. And I also thank the student coordinators who actively participated in the preparations leading up to the successful conducting of this webinar. Last but not the least, I must thank all our students for attending this session. Thank you all once again.
I thank you all for being patient listeners. I don't know how much of it is going to help you, but I have definitely made my attempt with a lot of search and compilation of judgments.
It was
Hope it
very
helps you.
informative, sir. Thank you once again.
Thank you. Thank you. Thank you.
Thank you, sir. Thanks a lot, sir.
Thank you.
This really, thank you, sir.